Okay, welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be taking it from 12 to 3. Guys, you know if you're on this network, it's a Dan Abrams production. Gavel to gavel coverage on the most interesting trials going on throughout the nation. Our prosecution's opening statement in the penalty phase of Markeith Loyd. Let's get to it. Kirk Burkhalter is a professor at NY Law, 20 years on the New York City Police Department as a first grade detective, long-term investigations, organized crime, criminal enterprises, and terrorism, and a frequent guest of mine. And all-around good guy. Welcome to the show, Professor.
Great to see you.
Okay, and Latonia Hines, who I also have the pleasure of via, I guess, Skype here today. Latonia is a prosecutor, assistant solicitor general, consultant for the Cobb County Police. She does a lot with public safety out there, and she is also a hardcore Gator fan. I love that factoid about you, Latonia. How are you?
I'm well. It's good to see you.
Okay, I'll start with you, ladies first. All right, give me an idea, these aggravating factors, and they're allowing a police officer to testify about a previous assault. One of the issues I have with the death penalty, even though I've prosecuted death penalty cases, so it may sound odd, is how the states vary in what they allow to be introduced. What are your thoughts about that, Latonia?
Well, I mean, you're right. Every state is different, and sometimes it seems even more prejudicial to have that information kind of being heaped on. But in this case, the reason why it's important is because you get the information that here's somebody who was out on probation, who was being told you're not supposed to violate the law, and still they're still violating the law. More so than just violating, you've killed somebody. You're responsible for the deaths of people. And that's why this is important, to show that this person is not, this isn't a first-time offense. This is a person who has spent a lifetime of violating the law, illegal activity, and why that should be an aggravating factor for this death penalty situation.
Okay, Latonia, interesting, very good prosecutorial perspective there. Professor, put your defense lawyer hat on here. You're teaching a lot of kids about this stuff. I mean, maybe to Latonia's point, it would be admissible because it clearly is an aggravating factor, but I guess the problem that I have with it is, why is it that the witness, the victim, is going to be coming in to testify? Isn't this one trial, one conviction, one sentencing? Aren't we kind of piling on by putting the actual victims on?
Well, that's always the argument. You know, to your first point, one of the problems many folks have with the death penalty is exactly what you said, that it is not administered equally across every state in our land. So you commit a crime in one state, you're liable for the death penalty, another state you're not, and the evidence that can be introduced. As far as the witnesses, victims testifying, this is another complaint. So people who it wasn't relevant for them to testify at trial, they didn't testify at trial, now in the penalty phase you bring these extra folks in. So that's another criticism.
Yeah, I have to say, that was my big criticism when I was doing it, and after having actually done it myself, is that certain courts and certain jurisdictions do it so differently, it's so disparate, and the introduction of evidence can make a big difference, whether it's in one case and not in other cases, to whether you get life or death. And so I don't know, I always found it to be very confusing when we're talking about the ultimate penalty. Nevertheless, it is a factor in this particular case, and the prosecutor, sure enough, opened up to it down there in Florida, where execution they're not shy about it. Let's put it that way. Let's take a look. Okay, defense opening statement. Professor, we talked about this just before we got on air with some of the crew here. They're putting a very aggressive defense on in this penalty phase. We haven't necessarily seen that in all the penalty cases that we've covered, which I was very interesting because in my perspective, from my cases that I handled as a prosecutor, defense had a lot of expert testimony, brought a lot out about the deprived life of many of these individuals that get themselves involved in these situations. And it appears our own Jesse Weber, our very own, was very moved by mom's testimony on favor of the defense. What are your thoughts?
Well, that's exactly what the defense is counting on, I believe, here. This goes to the heart of what the jury believes about punishment and the death penalty. So on one hand, the defendant has demonstrated that he's consistently going to operate outside the law. That's why they're bringing in what occurred with the law enforcement officer 21 years ago. On the other hand, the defense is basically stating, look at all the things that Markeith went through in his life. What else would you expect? And opening with, make no mistake, he's going to die in prison. We're talking about life or death. We're not talking about whether or not he will actually get punished.
Yeah, Latonia, to the professor's point here, let's make sure our audience is clear and our true crime aficionados that are in our chat room. The death qualified jury means that each of those jurors said if the aggravating factors were proven beyond a reasonable doubt and outweighed the mitigating factors, that they could impose the death penalty. And most jurors are okay with that, except when they have to actually be the individual that makes a decision. And that becomes a human dynamic that is very, very different different. And when you add that to a good defense lawyer who basically says it'll be more torturous for him to spend his rest of his life in jail and to die there, and please don't do this to mom, you could get one, no? One juror.
Yeah, especially when all you have to do is get one person. I mean, I've seen it before, and we've seen it in high-profile cases. If you remember the courthouse shooting that they had here in Atlanta, Brian Nichols killed 4 people, one of which was a federal agent, and he killed 4 people, but he was convicted, but he didn't get the death penalty. They put on evidence much like this about his childhood. His mother testified, and those mitigating factors were enough for at least, not to be able to have all the jurors decide that they wanted the death penalty.
Yeah,
and so they're doing a great job here.
Yeah, and Professor, let's do a theoretical, hypothetical exercise here. You could take Markeith Loyd's trial, in my opinion, in the penalty phase, and you could present it to 4 different juries, maybe within the same state, or if you do it in different places throughout the country, and you could get different results with respect to that. When it comes to the ultimate punishment of execution, even as a prosecutor, I just didn't trust the system enough, even though I was convinced of their guilt, and even though I thought the death penalty may have been the appropriate penalty. I have been there where defense lawyers didn't do a great job. Things were missed. Human error occurred. Well, it's really rough territory.
And that is, those who oppose the death penalty, that's their primary argument, that it's dependent on it's not dependent on the victim, I'm sorry, the defendant's crime, it's dependent on their representation. So you and I both commit the same crime, however, my representation is far more superior than yours, there's a greater chance I'm not going to be put to death. And like you said, you could take the same trial. I'll tell you what, here in New York, he would not be put to death.
Yeah, well, very interesting point the professor brings out, because their different juries can come up with different results, but the evidence rules are different in each state as well as to what will be allowed and not allowed. Woo, wow, man, we got it going here with some great guests here at the Law and Crime Network. Stick with us. We got a lot on the plate. And, of course, our third special guest is powdering his face and going to be making an appearance. Go in the chat room. See if you can guess who it's going to be. We'll be right back. Okay, Professor, I like the cadence of this defense lawyer and the little smirks and the intonations, and that's a nick on the prosecution. I got the transcript, so I'm going to be able to cross-examine. And they're basically bringing out injury to the hand, and that when the cop grabbed him, you're a former police officer, you've been around the block and know the rodeo. He had been kidnapped and beaten, previously. So they're trying to bring out all these mitigating factors to say this guy just had a really, really rough life and bad encounter. So I'm curious as to what your opinion is about that. And off camera, we were kind of talking a little bit about this race issue that he keeps bringing up, a white police officer. And do you think that's effective or not?
Well, it depends. So first of all, this is a preemptive strike, knowing that this police officer is going to testify. So bring this out. I have the transcripts, and this isn't, what you're going to hear. Kind of, I think you mentioned the phrase once, "Don't believe your lying ears." This is what really occurred. And then this issue of race. So that's always a touchy subject. Could it be relevant? Absolutely. Is it necessary? Well, that's the big question. So it's not lost on this prosecutor what's been going on in this country with these various shootings of African Americans, and there's tension, and there's always been tension between the police and communities of color. So it's a risk. Sometimes it may work, but it could also alienate the jury, right? This is one more, oh really? That's the excuse? That's why this person should live, because he's black and so forth. So you really don't know. I think it's always tricky using quote-unquote race.
Well, listen, great analysis. Latonia, you are going to have the next question, I promise. But we got to do some business here at the Law and Crime Network. We got a lot on the plate. We're going to take a break. We'll be right back.